Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkaram. In this video, we are going to study the purpose, object, and need to study or utility, I can say, utility of the jurisprudence. So first of all, you have to know the purpose of law. Already in the last class, just I have given the tips. What is the purpose of law? Now we will discuss in detail. The main purpose of law is to maintain L and O, law and order. The main purpose is to maintain law and order in the society. And they have to see that peace shall prevail in the society. And for this, they have to perform the so-called police functions. Of course, days have changed. So, with the due diligence in the jurisprudence, we have come to the welfare state, not police state. Ours is welfare state, whatever it is. So, here the main duty, the main purpose of imposing the law is to maintain law and order and to keep the and preserve the peace. Peace means when peace will be there, when the public order is there. So, you have to know the difference between law and order and public order. I will give you certain example, then only it will be easy for you to understand. So, what is law and order means? If you take out a procession, if you hold a meeting, so there should be law and order. Means the law should be applied. That means you have to take permission. You have to select the ground. You have to conduct the meeting only at that place. So, according to law, you have to take permission, you have to maintain the time, that is law. Second is order. Order means you have to keep them in a proper order. That means you have to arrange chairs, make them sit or make them not make any noise, let them not cause obstruction to the passers-by. This is what is called order. So, with the law, you have to maintain law and order. So, therefore, please remember, everybody should follow the law, should adhere to the law. చట్టానికి ఎవరు అతీతులు కాదు. Everybody has to follow. Then what is public order? This is preservation of peace అన్న చోట చెప్పాల్సి వచ్చింది. What is public order? Public order means, suppose if in some place, ఒక busy place లో some rowdy attacked an innocent person with some axe or with some swords and killed him, then what happens in that area? The public will be panicked. They will be afraid. Immediately, they will close down all the shops, they will shutter down all their houses and remain in the same or run away. వాళ్ళంతా తలుపులు మూసుకుని ఉంటారు, ఇంట్లో ఉంటారు, షాప్లో అయితే షట్టర్ మూసుకుని వెళ్ళిపోతారు. ఎందుకని? బికాస్ ఆఫ్ ద ప్యానిక్. సో దిస్ ఈజ్ public order. The public order should not be disturbed. So therefore, the main purpose of the law is to maintain the so-called law and order. And by using the law, what happens? Status quo can be maintained in the society. Status quo as it is. Yes, if something happens, if the police goes there, shortly you will use opening the shutters. Is it not? That is the law, legal power, the enforcement power. Then it gives or it enables people get more freedoms. You all know Article 19 of the Constitution. It gives different types of freedoms. Freedom to speak, freedom to express opinion, all these things. Freedom to move from one place to another. So, with the help of law only, you will have the so-called freedoms. And please remember, it is the law which satisfies the needs of the people in the society. For example, Mahatma Gandhi National Rural Employment Guarantee Act. Yes. Food Security Act. Yes, they are appearing, they are actually satisfying the needs of the people. So, this is the purpose of the law. Then, objectives. What are the objectives? Please remember, they make the law. Why? The objective is to see the rules of the law, or they make the rules of the law, they are generalized. They will be useful to all the persons. And the object is to have uniformity. That's why entire civil procedure, CPC, entire criminal procedure, CRPC, entire procedure, that is crime and punishment, Indian Penal Code, like that they have codified the law. Then the need for flexibility. So this is where the law is more important. So law is, it's not static. It's dynamic. At the same time, it is flexible. That means, for example, the police are not empowered to release the persons who are arrested under non-bailable sections. You all know this. Police can release the persons only in bailable offences. In non-bailable offences, who are the competent? The courts are the competent. But the flexibility is given in section 41 by amending 41A, which came into existence as per Amendment Act 5/2008, which came into force on 1/11/2010. Now, the police have got the flexibility. They need not arrest the accused. Simply, they can give 41A notice and he can be sent to the court along with the charge sheet directly. He need not be arrested. This is a flexibility. So definitely law creates the need, or it's the flexibility also. Of course, there are some difficulties also, because the law is, the sections of the law are not that easy to read, and they are rigid as well as fixed also. That is also the problem is there. Because at the time of the breaking of the law, they have to corner, they have to think over so many directions. Then only they can frame the law. It's not that easy. Normally we'll be commenting, oh, those people sitting in AC room, they prepare the law. They will, మనకు తీసుకొచ్చి నెత్తి మీద పెడతారు. It's not correct. They will think over matter. For example, మీరు ఒక సెక్షన్ తయారు చేయండి, ఎంత డిఫికల్టీ ఫీల్ అవుతారు. ఇదైతే ఏంటి, అదేంటి, ఈ ప్రాబ్లం ఏంటి అనే దానికి వస్తాం. కాబట్టి, so please remember, sometimes the rules are rigid rules, and of course the court will give only to the weight to the so-called evidence. If at all anything is there, the benefit or doubt will be given to the accused person. So that's why sometimes మనం లాని కూడా నమ్మలేం. ఎందుకంటే సిపిసి అయితే ప్రిపాడరెన్స్ ఆఫ్ ఫ్యాక్ట్స్ జరుగుతుంది అని అనుమానం, బట్ సిఆర్పిసి అయితే కంపల్సరీ కన్విక్షన్ రావాలంటే దిస్ హ్యాస్ డన్, వీడిది చేశాడని ప్రూవ్ చేస్తే తప్ప రాదు. మరి చుండూరు, ఫర్ ఎగ్జాంపుల్, చుండూరు కేసులో ఆల్ ది అక్యూజ్డ్ వర్ అక్యూటెడ్. డూ యూ మీన్ టు సే దట్ నోబడీ కమిటెడ్ ది మర్డర్ ఆఫ్ దోస్ పీపుల్? డెఫినెట్లీ they have committed, but due to the argumentative capacity, or due to the flexibility, or due to the loopholes in the law, they could come out. Of course, there should be there. Law అంటే అదే కదా మనకు తెలిసిందే, ఒక చోట అవునంటే ఇంకో చోట కాదనుంటుంది. Therefore, law is not static. Law is dynamic. It changes according to the changes in the society also. Therefore, flexibility should also be there. And now, what is the utility of the jurisprudence? Better understanding of the law. సో మీకు లా కోర్స్ ఎందుకు చెప్తాం, అక్కడ ప్రాక్టికల్ మీరు లా కోర్సులో ఇట్ ఇస్ ద ఫౌండేషన్ కోర్స్. వన్స్ యూ గో టు అన్ అడ్వకేట్, మీ సీనియర్ దగ్గరికి వెళ్ళంగానే లా కాలేజ్ చదివి పక్కన పెట్ట ఆబ్సెంట్ పిటిషన్ రాయ్, లేకుంటే పలానా మెమో అయ్యి పిటిషన్ అయ్యి బెయిల్ క్యాన్సిలేషన్ ఇది చెప్తారు వాళ్ళు. బికాస్ దే నో దట్ యూ హ్యావ్ గాట్ గుడ్ ఫౌండేషన్. సో ఇట్ ఇస్ ద ఫౌండేషన్ for understanding the specific law. Then, by studying the jurisprudence, you will understand, or you will know how to remove the complications in the law. How to remove the complications? By interpretation. Of course, it is the job of the court to interpret the law. We'll come to that in separate topic. Then, bring reforms of law in a legal system. So, jurisprudence, how you have made the law. By studying jurisprudence, you are knowing how the law was made. But if you want any reforms, unless you know the jurisprudence, you cannot do that. So, for bringing reforms in the law and legal system also, and for getting the educational and academic changes also, definitely you have to study the jurisprudence. Otherwise, you do not know the concept. What is the concept by making this law? What is the intention of the makers of the law? This you have to know. Otherwise, it will be very, very difficult. And jurisprudence adds to your understanding the theories. So the theories like utilitarian theory, Volkagist theory, then so-called pure theory of law. If you know them, jurisprudence, if you know it in the jurisprudence, it will be very easy for you to understand the law also. And jurisprudence, as I already told you, it will tell you the need of the law. This is more important, need of the law and the powers of law, right? So this is the objective, purpose and utility of the jurisprudence. With this, I am stopping. Thank you very much.